So some of you might know that I occasionally make little predictions about cases that are in the public eye, but I can't always make my predictions public because, well, they're public cases. And if they're ongoing, then there is a risk of those cases being jeopardized, even if it's a small risk or whatever. And this post office scandal is no different. I sometimes make my predictions privately, and then I feel like I have to share them with you. So, in fact, in relation to this post office scandal and the CBE of Paula Venables, I said privately in a message, I said, I think they will either rescind it or she will hand it back beforehand because of the amount of pressure building and over 1 million people voting for this CBE to be removed. I then, in the same message, said that I might do a video on this, and also it's election year, so she might be under pressure and anything can happen. And my dear wife replied to say that I think you're absolutely right there. So we have these little discussions between us. But what I also wanted to address in this video is that there's been significant backlash on social media forums about members of the bar that have prosecuted these cases. Now, what I wanted to re-emphasize in this video, which I've done so before, and hopefully people remember, but I want to emphasize it anyway, is that as a barrister, we don't, if we are instructed professionally, that is, we don't pick and choose cases. Now, if we are acting on a direct access basis, for those that don't know what that is, that means that we don't act with a solicitor between us and the client, which would be a professional instruction, i.e. the client goes to a solicitor, the solicitor in turn instructs a barrister. If it's on direct access, it means we work directly with the client. Now, we can refuse cases that are on direct access. And we don't really need a reason to do that, so long as we're not discriminating against anybody. We don't need a specific reason. We can just decline the instructions. However, if we are professionally instructed, for example, in this post office scandal, if barristers are professionally instructed to prosecute or defend one of these cases, then we have to accept those instructions. Now, there's been a significant backlash and criticism of barristers that have been prosecuting these cases because, after all, eventually it turns out that they were wrongly prosecuted and now we're looking to exonerate them. But at the time, on the evidence, it's not the barrister's job to decide whether that evidence should be believed by a tribunal. That is the job of the tribunal. It's either at the magistrate's court, or if it's at the Crown Court, it's the job of the jury to make a finding of fact based on the evidence. Our job is to assist the client by raising their evidence and by cross-examining other witnesses and their evidence, and therefore between prosecuting counsel and defense counsel presenting and help to present the evidence to the court so that the court, the tribunal, can make a finding of fact. I make the distinction because in the magistrate's court, there's obviously no jury. It is the bench that will make the finding of fact, whereas in the Crown Court, obviously, the jury is the finder of fact. The judge makes rulings on the law, makes rulings on what evidence is admissible, inadmissible, and so on. Responds to applications, for example, bail applications, all those sort of things. Obviously, the jury don't decide any of those. That's the judge's job. But when it comes to a finding of fact, so if someone's prosecuted for fraud, for example, it's likely going to the Crown Court, and therefore it's likely a jury that's going to decide. But the barristers involved will raise the story in what we call evidence in chief of the person who is being charged and prosecuted for the offence, and they will cross-examine other witnesses in the case, the prosecution witnesses. Conversely, the prosecutor will, if the defendant has chosen to give live evidence, which they're not obliged to do, if they have chosen to give live evidence, obviously the prosecutor is then entitled to cross-examine the defendant, and it's the prosecutor's job to cross-examine the defendant and put the Crown's case to that defendant. Now, there are questions raised which myself and my learned friend Alan Robertshaw, we are going to look into and consider and discuss and perhaps do a joint video on very shortly, more of a free-flowing discussion perhaps, as to why these prosecutions went on for so long after the story broke and so on. But on the face of it, if the evidence was presented and they were essentially privately prosecuted by the post office, then in turn, they will instruct a barrister to prosecute the case, and they have to accept the instructions if it's a professional instruction. And of course, they have to present the case as it is. So that is really just to dispel the myth that the barristers prosecuting this were in any way unfairly or unjustly standing against the defendant in these cases. It's very much not the case. Barristers have to adhere to the cab rank rule, which is a rule in our handbook, which means we have to take cases as they present without any favour or prejudice or anything else. There are only certain times when we may withdraw and or refuse, and certain times when we must. Obviously, if there's a conflict of interest, which is not quite what everyone seems to think it is, but if there's a conflict of interest, then we must refuse in certain situations. But I hope you found that interesting. I hope you found my prediction enlightening. Please do subscribe for more secrets and the behind the scenes. And of course, I thank you for watching.